rights, and obligations and duties. So those things has to be managed among the stakeholders. So this is the story, the starting point of the story of contracts management. So keep in mind, contract document has so many elements. So where we have to manage. See, yeah. And each of element has a different or unique obligation and duties, rights inside it. So what is the obligation? So what is the duties? What is rights? We should have a proper idea upon that as well. Obligation is a act or performance that we have to deliver in under the contract, right? And the rights is also the thing that we get in return by performing that certain obligations. And also when the other party, breach this certain obligation, that right become a compensation for the damage caused by that obligation. So those are the main two things that we see in each element. And in addition to that, we have duties, which is more assigned for the engineers. So those are the three things, right? We can see in the contract document each and every element in somewhere hidden or somewhere expressly given, and some places we have to interpret by ourselves. So this is the the core of the contracts management. That means managing obligations and rights and duties. So the obligation duties, right? Who is applicable for this? There are a lot of stakeholders in our contracts. So each and every stakeholder under the contract, especially contractor and duties under the contract. So in order to perform, we should be able to identify or recognize what are the obligations that we should be performed under the contract. And as I mentioned that very unique, scopes are very unique from project to project, and the stakeholders are also different from project to project. So obligations keep changing. It is very dynamic thing when it comes to contracts. So you need set of skills or the experience to recognize what are the real obligations that I should perform in a contract, and what are the duties that I should perform as an engineer or the interest representative under the contract. So those are the things that they expect. And in the meantime, most importantly, most sensitively, they try to reserve or they expect to reserve rights under the contract. Rights is the return what they get out of the contract. For example, employer if he expects to have a proper building or whatever the project that you expect, maybe if government, maybe it's an infrastructure. For a private client, it may be high-rise building. That is his expectation. That is his rights at the end of the contract. And also, on the other hand, by delivering that, the contractor is expecting to get certain profit out of the project. So that is his right. So both stakeholders or the both parties want to reserve it. If they fail to reserve it, that become a loss to them. So nobody wants to have or to get lost after the contract of project runs over 12 or 18 or 24 months after engaging such an endeavor at the end, if they don't get what they deserve or deserve. So what contracts management does. So as I explained before, contracts management is a continuous process that ensures the stakeholders performing their obligations, duties, and at the same time preserving their rights. So this is the process comes under contracts management, which is very important, which is very sensitive for the stakeholders. So let's see what a contract manager is. Contract manager is a key professional who drafts, interprets, right? Those two terms are very important. Is the person who draft or interpret the contract document. Contract document means all the elements I saw you before, and ensures obligation and duties are performed by stakeholders, and same time their rights are in place that impose they are getting what they deserve. So manager in the contracts and contract. So let's see. So I believe and contracts managers practice range starting from the pre-contract stage. At the early stage of the pre-contracts, and it runs over to the discharge letter of the project. That is the range of practice of a contracts manager. But most people think contracts manager comes in the post-contract stage, not in the pre-contract, and it is very wrong. If you go to the literature, or if you go to the contract project procurement strategic management publications, so you can see how important to have a contracts manager in the pre-contract stage. So you can eliminate so many ambiguities, dispute at the post-contract stage by performing or by having a proper contract management practice in the pre-contract stage. Let me explain that. So we can divide the practice area into 3 stages. First, we can take as pre-contract. On the pre-contract stage, as I mentioned, 90% of the contract document is produced at the pre-contract stage, right? So that means, as I mentioned before, the 29 elements, I'm just taking it as an example for the number, right? Uh, so all these elements, right, prepared or drafted at the pre-contract stage before the awarding or before the bidding. So if if you put a relevant or adequate attention and the time and the planning into the process, you can maintain a very consistent document among these elements in order to avoid the ambiguities or the contradictions or the issues within the contract documents. So those things will not come up when you execute in the contract at the post contract. In that way, you can avoid so many disputes, so many claims, so many issues. So ultimately, it will ensure all the parties' rights were reserved. So as a contracts manager who practicing over 7 years, I believe having a contracts manager at the pre-contract stage more important. It can make a huge difference rather than having a few contracts managers in the post-contract stage. So think about that. And the contract stage means the small gap between the tender end of the tender process and the forming the contract, right? Before once you select the bidder, until you sign the agreement with the MO, until you issue the letter of acceptance, you have a certain period where you both parties do the negotiation or do the correction or study all the elements before signing. So you are getting a golden opportunity, again a second chance to correct all the issues, all the ambiguities and all the discrepancies within the contract document or the bidding document, which is about to be a contract document, to be corrected. So this is a very golden second chance, I may say, to eliminate a lot of issues that are going to happen in post-contract stage. So the impact or the practice of proper contracts managing this stage also very, very critical. Then if you go to the post contract, that is pure implementation. So whatever the terms or the obligation rights that you agreed upon at the time of making the contract, now we have to make it into action. That means implementation. So if the party breach any obligation against you, you have to reserve the rights upon that or against that to get compensation. Or if nothing happened, then you have to reserve your right or whatever the thing that in return for performing those obligations. So those are the main 3 stages we can see in the practice range of a contract manager. So let's move into the specifically for the post-contract stage. So the post-contract stage, our practice or the contracts management start from commencement for the first day of the implementation to the last day. That means last correspondence that we will be drafting for a contract will be the discharge letter. So from right from the beginning to the last draft or the last letter that you are sent, your practice is required. So all the things will be going through you. So that is how important of a contracts manager in the post-contract stage. All the contractual correspondence, there will be thousands of correspondences in a contract for a 12-month period of project. So all the things you have to be drafted or interpreted by you in order to ensure the smooth proceedings of the project. So when you come to the post contrast, we can see is the certain discipline which is more important when you consider the process or the life cycle of the post contract period. Especially we have the commencement at the beginning, then we have monitoring and the change process and the payments and the claim procedure and the dispute procedure and the closeout. So these each stages or each discipline have very unique or specific obligations, sorry, and rights and duties assigned around. We are at the stage of commencement. We have to recognize those obligations of a contractor. If you are working for a contractor from the employee side, you have to recognize what are the obligations that assigned to him under the contract. For example, he have to give the possession of site, whether I'm going to do the run the possession site in full or in the segments. Likewise, differ from project to project, but you have to understand what is your real obligation and perform it. If you fail to perform it, it will become a breach, then it will give a right to others party. So from the other parties, a contracts manager have to recognize whether the employee had given you the possession of site as given in the contract, then it is okay. If it is not, then there will be a breach or there will be a damage for you in terms of delaying the project. So you have to reserve your rights. You have to place your notices, then you have to prepare claims. Likewise, I'm explaining as an example with the limited time. So likewise, in each stage, each in different discipline like commencement or monitoring means the scheduling with the program thing. The change process means variations, payment process, claim procedure. Each discipline has different colors of or different dynamic obligations and duties and rights around them. So contracts manager have to recognize this, you have to interpret this and make it to action. So this is the role of a contracts manager in post-contract state. For if you go for another very sensible or critical stage in post-contract under payment process. So when you come to payments, in the normal contract, we have three types of payment application: normal inter-payment application, and the application we said, oh, we submit at the taking over, right? And then the final draft at the end of the project. So the payment application we send at the state at the taking over, it's very important. We call it statement of completion. So when you submit a statement completion, contractor is obliged to include all the due amounts that he expected under the contract. That means all the claims he is expecting to pursue or already pursued and not reserved dispute expect under the contract, and all the works he expect to perform during the defect notification period. And if there are any disputed variation or any kind of items which due under the contract, we have to put that all thing into the statement completion when we are submitting it. If you fail, that is the obligation of the contractor when it comes to the payment, right? But if you miss that, the employer will be discharged from all the liability upon those due payments for the contract. So see how important and critical it is to the contractor. So simply, even he is damaged and even he costs a lot of money, if he unable to put that figures into a submission or the document he's submitting at the taking of the project, he will lose his entitlement to get the money back. So that much important or that much effective of the practice or the practice under the contracts management. So having a qualified or competent contracts manager is very important for all the stakeholders to reserve their rights under the contract. Another example we can say regarding the claim process: if you're having the contract of FEDIC firms, and notice of claim is concerned precedent. That means it is time barred and concerned precedent. If you miss or if your notice lapse the given time period, which is 28 days most of the times, you will lose the entitlement of claiming whatever the damage caused by the employer by breaching his obligations. So that is how it is, right? So we have to apply for our obligation timely manner. If we get late, so you're losing your entitlement. That means at the end, it will make losses for you. So that's the that is how it is, I would say. So in order to perform such an important effective task or the practice, right, we need to recognize the obligations or duties and rights. I will keep repeating these three words because contract management is all about these three things. Okay, and we have to recognize these things among the all the elements given in the contract. As I mentioned at the beginning, this is a contract document is a very huge document. There are thousands of pages inside, and there are different elements, more than 25 elements in the normal contract. So each element contains a unique, specific obligation and duties and rights. So whatever the party you are in, that means you may in the contractor party or maybe in the employers or maybe with the engineer, you have to recognize what are those given in the contract. So how we do that? What we do for that? We call that interpretation, right? We have to interpret those things. Some are given expressly, some are not, some are implied. Anyhow, we have to interpret the document in order to get out these obligations, duties, and rights. Right? That's the only way that we can perform or reserve uh, our obligation and rights. Before moving to the interpretation, I have a small task for you. I want you to read this sentence very carefully. Sentence says that I never said she stole my money. So this is a simple sentence with 7 words. So try to interpret yourself. Then I will show you my interpretation. Then you can compare whether it is matching or not. Okay. I will give you a few seconds. Then we can try it on. I never said she stole my money. Okay, this is my interpretation. You can compare with yours. I say, I never said she stole my money. That means I'm saying that someone else might have said that. So that is my way of reading or interpreting that sentence. I hope you have the same or you might have a different. But in the same time, I have another interpretation. I never said she stole my money. It means, I mean, it never happened. Wait, I have another interpretation. I never said she stole my money. That means I might have implied it, but I didn't say it. Likewise, I can have 7 interpretations. Okay. Sentence contains 7 words, and also we can go for 7 interpretation. So, okay, I think you might have a different interpretation with you right now, addition to these 7. So I want to emphasize the point that interpretation is very difficult task. That means interpretation comes out of us, and it depends on our education, our background, our culture, our beliefs, and our perspectives of things. Likewise, it depends on so many things. It is a very individual thing. So imagine now we try to interpret. So very simple sentence with 7 words, and we are getting more than 7 interpretation. What about the contract document? It has 1,500 pages. Okay, 29 elements. So many stakeholders, right? So how difficult would it be, right? Is you think about international projects. Now I've been working in Middle East projects. there I see a lot of different people from different location of the location. There are different countries. You can see British people over there, Indian, Pakistani, Sri Lankans, Sudanians, and Arab guys. Likewise, there are different professionals from different natives. Think about that, right? Now they are in a very different geographical area, culture, religion, education system, everything is different. So think about that kind of different or diversity is going to interpret the contract document, how many interpretation will come out, what a chaos it be. So that is how difficult is the interpretation, right? So how we can manage this? Now, so far we are managing, right? There should be a way. This is the only way that we need of a framework to interpret the contract document. So that is the only way. I think we can have a similar arrangement regarding the taking of quantities from drawings, which you might be more familiar than this. Think about the method of measurement, right? And we have a set of drawings. If you given to set of drawings for 10 people, they will take off quantities in a 10 different ways. That's why we have method of measurement with certain rules that 10 people can follow, then we can get more similar outcome, right? So basically simple, that is similar kind of concept applied here. That means we are going to have a certain interpretation framework in order to interpret this contract document, which contains thousands of so many elements together. Okay, let's see what is this framework, right? Okay, so if you go to Friedrich Nietzsche Red Book or any standard form of contrast, you see this definition. That is the first section we can see in the contract, which is a definition. So in definition, I can hope you can see the screen clearly. You will be getting certain terms which is interpreted here, which is given a specific definition, right? For example, here contract, they have given a definition. For the contract agreement, they have given definition. The specification they have given, drawings they have given, schedules they have given. So what does it mean? How it's going to apply? Let me explain, right? That means if you see this term, right, in your contract document, in any kind of elements, if you see the term specification starting with capital S, that means this specification term means the specification given in this section. That means 1.1.1.5. It defines specification in a certain way. If you see specification with capital S in anywhere in the contract document, it means the definition given here. So this arrangement clear out so many things. Otherwise, 10 people could define specification in 10 ways, right? Then they will put into the paragraph or the sentence, and they will give a different interpretation based on their interpretation on the specification. We can avoid that by having this kind of set of definition words inside the at the beginning of the contract document. So this is a very common framework that we are using in standard forms. And let me explain this further with more familiar word that the cost, right? In every contract, you can see a definition for the contract. The FIDIC contract defined with this capital C, and also in somewhere we can see the cost with simple C as well. So what is the difference between capital C cost and simple C cost? In the capital cost C, there's a definition given in the contract that it is excluding the profit and all the expenditure incurred, but not including the profit. So if you see capital C somewhere in the contract document in any element, that means it is excluding profit. But if you write the cost term in simple terms, that simple C, that means it including the cost or whatever the definition that you want to put, because it is not capital C. All right. When you are drafting correspondence, contractual correspondence, I mentioned you have to draft hundred of correspondence during the implementation. If you are referring a matter related to these terms, you have to be very careful. You have to, if you mean if you want to mean exact definition which is given here, then you have to use the capital S, which this look like very simple, but it is very effective. It clear a lot of things, avoiding different definition for important terms in the contract. So that's one way that contracts avoid that kind of chaos when it comes to the interpretation. Another interpretation, we 1.2, we have given some set of rules how to interpret, and it talking about the genders and talking about the singularity and plurality of words and the agree to agree or likewise. Here we have set of rules which we can use when as a framework to interpret our contract document. So, and this is also another important provision given in the contract, right? And we call it private of documents, very popular among contracts managers. And here they mention very important thing. The document form in the contract are to be taken as mutually explanatory of one another. As I mentioned, contract documents has so many elements under few volumes, right? And under this element, we have, for example, let's take condition of contract. So if you go to the FIDIC, you have 20 clauses and we have 100 of subclauses. So it's trying to say when you are interpreting something or some clause, you cannot interpret it as an individual element. You have to think about the connection with all other elements as well. So you cannot interpret the clause independently to other elements of the document. You have to think about the intention and the flow and the connection and the construction methods related to those things mutually among other elements. So that is very important rule that uh, we are practicing when you are trying to interpret things. So keep it in that mind. And also this priority of documents and I mentioned there are so many elements, and most of the times projects and the projects we don't get a very paper contract. So if there's ambiguity among these elements, the priority one becomes one. But this is arbitrary. People or the practitioners have different opinion regarding this, right? And yeah, we can talk about that in coming sessions because this is a introductory session. We have a limited time, so I'm not going to go for that deep. I just want you to expose to those things with this limited time. Okay. So addition to that, right? Those are the only three things we can see in the FIDIC where we can use as a framework for interpretation. But in practice, among expert or the contract, using certain rules which we have taken from the litigations or the previous judgment or law cases, where how a judge of a court getting into things, how he interpret issue related to documentation. So there are certain case laws have happened in the past, and from that we have derived some set of rules which is in practice right now. And even the literature related to the contract management or the publication or the books related to the contracts management, you can see this interpretation rule. They recommend to use it. But I want to mention at the same time, these rules are not given in the contract, so it is not a part of the contract. So you are not obliged to perform this or use this, or you cannot use these rules against other because it's not included in the contract. No, in the contracts, in a standard contract, you can find these rules. So that is there also. But still, as a guidance, as a practitioner, as a guidance, we can use these rules to interpret our contracts. So those are few or or more popular rules that that are in use in most of the time. The plain meaning rule, contra preferentum rule, expressio unices, four corners rule, commercial purpose rule. Likewise, there are a list of rules that are in use in most of the time. The plain meaning rules means that you have to use the literal meaning given in the terms. You cannot go for specific styles. So the legal terms under that terms, you have to go with the given meaning of the term, something like that. Okay. The contra preferentum rule is it's very interesting one. So as I mentioned, in most of the contracts, we see ambiguities or we can see deficiencies or, the errors in contract document among elements. So once we come across such a situation, the ambiguity or the deficiency should be resolved against the drafter. So this is a very strong rule we see from the case laws that which is in practice as well. So if the situation or the ambiguity happened because of the default of the contract document itself, which is drafted by the employee in the most of the time, so it should be resolved against the drafter, that means the employee. That is uh, that is the meaning of counterpart rule. And also expressio unices. So these terms are from Latin. So this is also a rule that in practice that means the express terms in the contract become superior among the omitted terms, right? So I can explain with the example for that. For then you can get a better understanding. So think about the subclause 2.1 or 1.9, 2.1 for the possession of site. It says if the employer failed to give the possession of site, contractor will be, as an remedial action, will be entitled to time and cost plus profit. Okay. And the same thing happens with the 1.9 also, delayed drawings. If the drawings were delayed, the contractor is entitled for the time, cost, and profit, three things, right? But the same times, where if you go to 4.12, that means unforeseeable physical conditions. I'm referring this clauses through PDIC 99 grade. And if you see, if the project is delayed by unforeseeable physical conditions, the contract is entitled only for time and cost, no profit given, and it is silent. It's not saying contract is not entitled for the profit, but it is silent. So from the contractor's perspective, he might claim for the profit as well. He must take the position it is not explicitly omitted, it is silent. But from the business perspective, if I'm spending his money, I should be able to get the profit as well. From that perspective, he will take, right? But these rules can be applicable for this, right? Because in certain places like 2.1 and 1.9, it clearly expressly says profit is entitled. But in the 4.12, it is not mentioned, omitted. That means if you rule this rule, that means the things which is not mentioned is intentionally omitted, right? Where certain terms are mentioned and where certain terms are not mentioned, the omitted or the not mentioned items are, it is intentionally omitted or eliminated. So in that case, if we apply this rule into interpreting that situation with 2.1 and 4.12, the contract is not entitled for the profit, right? Under 4.12. So that kind of arrangement, that kind of application you can use from this interpretation rule. Four corners rule also saying that the contract should be interpreted only among the contract document elements. No other elements or other document outside the contract document you cannot bring it to action for interpretation. You have to do all the things within the given contract document. So likewise, there are so many interpretation rule you can search on this. So my goal today is not to discuss these rules in detail. I just want you to expose. There are these kind of rules available for the contracts managers to practice. So that is my intention. I hope you will go through these things and learn more about this interpretation rule, which is in practice, which is very helpful because when we are trying to interpret things, right at the beginning also for me, we are getting lost ourselves on the way of interpreting things because in the mind you will get a lot of options. Option A, you might feel option A is the best at the moment, but while when you are working further with the thing, the case, you will see more options, then you get lost and you get more stress or confused. So, but these rules help you to have a own guideline. You can plan the process step by step. So where you can save the time, you can avoid so many confusions. So likewise, in my experience, these rules are very important and very useful when it comes to interpreting the contracts documents. Okay. let's go. What are the skills and competencies we need to become a better contracts manager? So basically, we need communications, which is very important, verbal and writing, and also functional. Here, I mean the ability to interpret the contract terms as we discussed, right? So these two skills are very important and depend each other. So being a better communicator is not going to work if you are not good at functional skills. Having a good skill of interpretation or functional skills not going to be effective without proper communication. Because communication is very important. We have to transfer what you intend to the other party. Then only you can get a better or more relevant response from the other party. So these two skills are very much important in practice of the contracts management, especially when it comes to communication. The writing skills is writing skills very important. That means when you are drafting a contractual correspondence, you have to use all the options available with the availability. For example, I can mention that you can use underlining the word, you can use bold, we can use commas, semicolons, upper commas. Likewise, all the features available to emphasize or the highlight the the essence what you are going to tell, right? So that is very important. In my practice, I always use these options when I'm writing a contractual correspondence. I want to get their attention, the reader's attention, to the most important part of the that document. So in order to do that, you can use certain skills or some options available with the Word or whatever. My point I want to highlight is you should be able to catch up the attention of the reader or the receiver for the most important part of the letter or the document. Right? That is very important. Then only we can response from them. Okay. The interpretation or the functional skills are very important. Without that, we cannot recognize the applications. And the soft skills also very important here, especially I means the leadership uh, and the uh, and the deal with the team. The leadership, if you talk about the leadership, when it comes to the contracts, management of a contract, so you have to lead, because the engineers or the architects or the surveyors or other professionals, they are not much familiar with the contracts, or they don't have a education behind that related to the contracts management. So you are the only person who has the ability and all the education and the experience behind the contracts management. So you must be able to lead that, and you have to be confident what you are saying or what you are writing to defend your position as well. So this is very important, and other people around you should feel that you are confident about your interpretation of the contract. So this should be with you. Then you will get the help of others as well. So that's why I think become a team or dealing with a team also very important, because you need some or lot of records or the facts or information in order to do your submission or to draft your correspondence. So those things are produced by different team players in the team. So you need to have a good connection with them in order to get those from them. Then only you can produce the proper submission related to the contracts management. So dealing with the team or working with different people who have different opinion going to be very useful when it comes to the contracts management. Anyhow, construction is a teamwork, so that skill to become a team member or act as a team member is going to be very helpful. Then the cognitive thinking is another important thing, right? When it comes to real situation and the practical scenarios of the project, yes, theoretically we talk about the that means employer help the contractor help the employer, and engineer also join together and jointly they are corporately trying to complete the project and make success to each other. But it is not the case when it comes to real situation, and people are having egos. Some all are humans, and they are taking their position against each other in the most of the time. So it become a kind of a game, right? So when the situation like that, you have to be very careful about what you are going to submit or what you're going to write or what you're going to say in a meeting. So you have to think about a few steps ahead. What happen if I do this, and how it will be response, and what will be my defense against that. Likewise, there are a lot of things to be think, right? So that skill is a kind of a requirement right now with the situation going on. So that cognitive thinking ability or the strategic thinking is very important when it comes to skills, right? Then the technological, the construction technology, the project management knowledge, and those two also will be a bonus. If you're having a good knowledge regarding the technology, then you can use that to interpret things very well. And also project management, especially resource allocations and scheduling skills, very important, right? So let's go, what are the competency? What I mean, the competency. So that means ability to apply skill appropriately. All the skill I mentioned before, you should be able to use appropriately in order to make the outcome. So it will be the competency. So let's move on to the what are the education options available for contracts management. The FIDIC Academy and College of Contracts Management College of UK, right? And Udemy. Udemy is also online platform where you can find contracts management course. And Metropolitan School of Business Management, IQSSL for Sri Lankan, SIDA, also the Sri Lankan Institute, where they provide the courses for contracts management, maybe in foundation level, intermediate or advanced. You can find those courses available in these things. And CPD also very important. Lot of institute around the world, they conduct CPDs monthly. So most of the time they go for contracts management related subjects. You can learn from there as well. So what are the professional qualifications available for countries, contracts managers? So this is the most prominent one at the moment, FEDIC Certified Contract Manager. So this is a certification issued by FEDIC Credentialing. So you can go to the website and see. Right now, there's only 190 people who has this qualification, but FEDIC has taken so much initiation to promote this assessment. Also, they are trying to spread this qualification among the industry. For example, now I see in KSA or the Middle East regions, they advertise job vacancies asking this qualification, and this qualification is highly paid, and there are only few at the moment. So it is a good qualification for you to target. And regarding the demand, I would say only two things, right? Numbers, I hope, let me explain in this 129 and 220. What is 129? This is number of pages of FEDIC 99 read version. And what is 22? 220, it is the number of pages of FEDIC 99 read book, sorry, FEDIC 2017 edition. So you can see the enhancement, right? This is almost 90%. That means you are getting more obligation, more time frames, and FEDIC 17 is more proactive contract management expert rather than compared to 99. That means there are a lot of complications, a lot of obligations, duties, and a lot of time frames, and a lot of deemed to be clauses. Likewise, it has been very complicated, and it is new at the moment. So there's only few people who knows that. So if you get familiar with this principle, you can manage that easily. Then you can get a high demand uh, in the industry. So let's try to wind up the things. The final thing I want to say why I am saying and why I believe that quantity surveyor is the best person or the best professional to become a contracts manager. So my answer is very simple because of the primary education you are getting. So you may have a degree or you may be following a degree or diploma, in whatever the case, you will learn about contracts management at your basic program. So I'm a graduate from University of Moratuwa. I learned whole year the subject related to the contracts management. So similarly in other institutes as well, I see their curriculum. They have allocated very considerable time for the contracts management principles. So that is, and we are the only people who are getting that kind of primary education in our basics for engineers, contractor, engineers or architects, maybe surveyors or other professionals don't have that luxury in their primary education. No, I'm not saying other professionals cannot be a contracts manager. I know people, I have friends who are engineers, architects doing very well in contracts management, but still I'm saying contract survey has the essence in self, in built, right? So you have to see that, you have to believe that, and you have to develop it that. You should believe, you should be able to believe that you have the ability and all the inputs inside you by completing a certain degree or a diploma to become a good contracts manager. So before wind up, I want to clarify one misconception regarding the contracts management, which I see among most of the practitioners in the field. The most of the time, people who think contracts management is limited to condition of contracts or with the particular condition. It is not. I hope you got that idea. Throughout the session, I try to explain there are so many elements within the contract other than the contract, condition contracts, right? Condition contract is only one element, but there are so many. So all elements include obligations, right, and duties. If so, we have to manage all these elements as well. So next, the recommendation I can give it to you. Use published guideline for standard forms, right? So if you think about the FIDIC 99 has a very comprehensive guideline published for each and every clause. They explain very details about their intention with example and all the things. And also new engineering contracts from UK also have their own published guideline. So referring to guideline will be a best way to understand what is the real intention behind that. So it's my recommendation for you to have the guidelines too and try to be familiar with that. So thank you very much. I think I ran out of the time. Maybe I apologize for that, for taking